First tonight, after Governor Greg Abbott signed the heartbeat bill into law today, local abortion rights groups and advocates are getting ready to take legal action.
The law prohibits abortions after a fetal heartbeat can be detected. Doctors say it can be as early as 6 weeks. It goes into effect September 1st.
KXAN's Jennifer Sanders takes a look at all sides and the legal implications ahead.
Whole Women's Health and Whole Women's Health Alliance are currently plaintiffs in 3 lawsuits against Texas. All challenge state restrictions on abortions. The agency is now working to block the heartbeat bill, signed into law Wednesday.
This law creates a lot of hostility and surveillance and a real difficult environment for providers.
Supporters of the legislation say this is an historic step.
It's making a strong statement that we think that the unborn child whose heart is beating and even before should be protected by the state of Texas.
Abortion rights advocates say this creates barriers for low-income communities, forcing people to drive hundreds of miles to access a clinic. About 13 other states have passed similar bills. The difference here, Texas isn't enforcing the law. Private citizens are. They can sue abortion providers or anyone who helps someone get an abortion after a fetal heartbeat is detected. Analysts say the law has a steep hill to climb to survive state or federal court challenges.
I think it's unlikely that before September 1st, there will be any action on this other than action to restrict this, and I don't think it will go into effect on September 1st.
In Austin, Jennifer Sanders, KXAN News.
Fetal heartbeats can be detected as early as 6 weeks into a pregnancy. Doctors say in many instances, women don't know they're pregnant at that point.
The U.S. Supreme Court has struck down Texas restrictions on abortion before. 5 years ago, the High Court overturned part of House Bill 2 passed in 2013. It required all facilities performing abortions to meet hospital-like standards. That included minimum sizes for rooms and doorways. The court also struck down a separate provision that required doctors to have admitting privileges at a hospital within 30 miles of an abortion clinic. Had the court upheld the requirement, Texas would have been left with as few as 10 abortion clinics in the state.